Yeah, no, it's going through. It just needs to be up a little bit.
Turn it up from there. Is the master volume from over there though? When I was...
Subject is -29, so he is coming back on
A little bit, maybe?
Aggravated battery on police officers in various jurisdictions.
Sounds great. Thank you.
Turn that on. Does it say 1 or 2? Only one. I wonder if this is the cable they're replaced. It can't be. I'll see that goes for the computer. This is for the laptop. You know what I mean? That would be if we put the laptop, like a laptop, you know what I mean?
That's what you want? All right. Oh, it doesn't look.
It's only on that screen. Okay. But it's not on It's not on video.
The
Red thing, I don't know what that is, dude.
That's not on video.
I think it's on the screen. See it on the
Yeah.
screen?
Yeah.
Oh, you know what it is? It's something someone wrote and touched the screen. Can we clear that red dot? There we go.
Bottom left corner.
Oh, is that what it is?
Just like a red suit.
Yeah, yellow gun.
It's a brand.
Yeah, it's very good.
Oh.
All rise, court is now in session.
Please be seated, thank you. Let's go ahead and go on the record. And let's call State of New Mexico versus Dominic Perez in CR 2015-00105 and State of New Mexico versus Keith Sandy in CR 2015-00104. Could I have council's entries of appearances for the record, please?
Good morning, Your Honor. Sam Brickman and Eric Loman on behalf of Keith Sandy.
Okay.
Good morning, Your Honor. Luis Robles, Nick Audio, David Roman on behalf of Officer Dominique Perez.
Okay, thank you.
Randy McGinn and Kevin Holmes on behalf of the state, Your Honor.
All right, thank you. And ladies and gentlemen, in the courtroom, I'd ask that please, if you have cell phones or any other electronic devices, that you please keep them in the silent mode so we won't disturb the proceedings as they go along. Counsel, I did receive proposed orders from both sides. I reviewed those. They appear to be mirror images of one another. I'm not sure, is there a disagreement on the orders, the proposed orders, counsel?
Your Honor, yes, I can speak to the two differences between the two.
Okay.
Although the state broke them into three different ones and we had them as one order, the first order, that being on the motion in limine to limit evidence of James Boyd's character, is identical. You're correct.
Okay.
The second order, the state's motion in limine to preclude opinion testimony, is different from the defendant's joint proposed order in one respect, which is the state's order took out language which Your Honor had used directly in your ruling, that testimony will be allowed by officers as to whether they thought certain means were necessary to quell the situation at a particular point. That's taken directly from Your Honor's ruling on Friday. The state didn't like that, so they took it out. We left it in, and that's the distinction in that particular segment of the order.
Okay. Any other comments?
We just joined in.
Okay. The state, do you want to respond?
Yes, Your Honor. Our concern is, while we recognize that the court did use those words, it appears that those words are in conflict with the beginning part of the order, which is that the officers may not offer opinion testimony on whether any given actions were reasonable or justified. And one could imagine a question along the lines of this. Because the court's words were whether they thought certain means were necessary to quell the situation at a particular point. And so let's imagine that the particular point is the point at which James Boyd is out with his knives at the time that the defendants chose to shoot him. Would ask any officer, at that particular point, what means do you think were necessary to quell that situation? And the response that would be elicited, of course, would be, shoot him. And that would be essentially going around what the intent of the court's order was. And so that's really the line that we had concerns with, because it's in conflict, I think, with the spirit of the order and the first part of the court's ruling on that. So we removed that because I think the remainder of the court's intent is reflected in the remainder of the order, that they can talk about their training, they can talk about their experience, they can talk about how they're trained to respond to certain circumstances. But whether they thought certain means were necessary to quell the situation at a particular point sure sounds like a different way of saying whether it was reasonable to act a certain way at a particular point.
Okay.
Your Honor, I believe that neither defendant intends to elicit that sort of ultimate issue opinion that the court's order was precluding, but I think that to take out the language that you had included would be overly restrictive, because there are numerous other points during the events at which this eyewitness officer's testimony about what he thought was necessary at that particular point, not just at the final end, but throughout, is entirely relevant. And if we were to ask a question that was considered objectionable, that seemed to be eliciting that ultimate opinion, then at that point, of course, an objection would be reasonable and we could discuss it then. But to take out the language entirely that you would use would be overly restrictive as far as timing throughout the event.
It was my intent, as we had the hearing on Friday, that the court was going to exclude any testimony that I certainly felt or feel that may go in the way of asking for a legal opinion. In other words, was there sufficient probable cause? Did the officer act reasonably? Did the officers act in self-defense? That sort of thing. Because as I stated, that is in the purview of the court and not in the witness's purview. However, the state, I think the line you're drawing here, although it's close, I think that what I will allow, and I agree with the defense on this, is that the officers can describe the situation and testify how they personally felt the need to use certain force at that point. I think that goes more to a lay opinion. So I want to stay away from any legal opinions, expert opinions that go to the legal conclusions, but I will allow the officers to testify to that, as I mentioned previously on Friday. I will approve the defense's order. I see there's only one order here as to Mr. Perez. I don't have a defense proposed order as to Keith Sandy, but this order will reflect as to both.
And Your Honor, was submitted jointly, and I think it's reflected on what we submitted, but Officer Sandy's
okay.
joining in.
Well, I'll approve the one I have here, and so long as we all understand it applies to both defendants in this case. And I will have the bailiff run copies for you later in the day, and we'll have it filed, and so you can each have a copy.
And Your Honor, before we move on, as much as I would like you to grant our submitted order in its entirety in candor, the third issue as well, the motion in limine to exclude standard operating procedures, has one small disagreement among counsel in it as well. That disagreement is that our proposed order, which I believe reflects your ruling on Friday, states that SOPs are excluded with the exception that if a proper foundation can be laid to demonstrate that a specific SOP was directly incorporated into the training received by a particular officer, it would be includable at that point as evidence of the training that they received. The state's proposed language instead is to say that a proper foundation laid to demonstrate that a specific SOP reflects the training received by a specific officer. And while that may seem like a distinction without a difference, we believe it's quite significant because simply looking to an SOP, and this gets to be why we were concerned with having them come in the first place, simply looking to an SOP and saying, did you receive training on this SOP, doesn't get to the point of knowing how they were trained to use that SOP. So for instance, when we talk about SOP on treatment of the mentally ill or approaching the mentally ill, and it talks about you as an officer need to speak with them in this manner, you need to approach them in this manner. To just look at the SOP makes it sound like that's every single officer's responsibility without taking into account whether there's a tactical plan and how they are trained on what that SOP actually means for each officer in a given situation. So just to say you had this SOP and it may have been part of your training, therefore we get to use the SOP, I think skirts whether it was directly incorporated into the training, which is what would be necessary to know how it was intended to be used, which is why the language is as we submitted it.
State, do you wish to respond?
Yes, Your Honor. Thank you. Relevant evidence is that evidence which has any tendency to make a fact of consequence more or less probable, Your Honor. When we met on Friday and discussed this motion in limine, it was clear that the court's concern was whether these SOPs would assist the court in understanding what a reasonable officer with similar training or the same training would do under the circumstances, and to understand what the training of these officers was. Now, we proposed the language that the foundation would be that a specific standard operating procedure reflects the training received by a specific officer. And so I don't think anyone could argue or would argue that a 1 or 2 page standard operating procedure is the total training that an officer received. But the words in the SOP, the language in the SOP reflect what training they did receive. It's the core principles summarized from the training they received. And we will elicit testimony that is consistent with that proposition, that these SOPs reflect the training that they received at various times in their career, either at the academy or through the Albuquerque Police Department. It's not everything, but it gives the court an idea of some of the things.
Any response?
Yes, Your Honor. I mean, the SOP standing alone doesn't reflect the training received, because without knowing how they were trained on the SOP, at best it's misleading. And if we're going to incorporate what the officer's training was as an example of what a reasonable action would be, then let's incorporate what the officer's training was and not take what a summary that may or may not be relevant or even how they were trained to use it is going to show. It's not clear what an SOP would offer that evidence of what training they actually received would not. It would just end up being misleading, especially if they were trained on an SOP at a time that wasn't the one that was in existence at the time of the incident.
Okay. On this particular issue, I tend to agree with the state. I realize at least we talked about the standard operating procedures as reflecting the training. I said I'd allow it so long as it reflects the training received by the officer. So what I'm going to do is, again, grant the state's part of that order. Perhaps we'll need to rework this thing. So what I would do is just with respect to defendant's paragraph 3 that I signed in their order, if we could just substitute their language for the state's language, and I think that will complete the order. Okay? And I'd ask that perhaps we just have another one drafted up so that reflects that before the proceedings end.
And Judge, there was one other thing I just wanted to take care of for Friday. Because this is a criminal case, I don't think the defendants cannot show up for a motions hearing without waiving their presence. And on Friday, neither of the defendants were present. And so I'd just like to put on the record that their counsel officially waived their appearance at the motion hearing that we had on Friday. And then after we do that, I have something to present to the court.
Okay, and you have to forgive me because I presumed that issue had been taken care of previously. I don't know. Mr. Bregman?
Your Honor, my understanding was that they've been waived for all preliminary matters before the preliminary hearing, but I'm certainly more than willing to state right now for the record that my client authorized me to waive his appearance for the purpose of hearing that motion the other day.
Mr. Robles?
In fact, Your Honor, I had filed a motion and had an order presented to this court, but since the matter didn't, I guess, somehow show up on your radar, I left it alone. But the motion was filed and the order is ready if you'd like to sign it.
If you prefer that I sign the order, that's fine. I think that all sides are in agreement on that. So, anything else from the state?
Just, Judge, we're going to hand you our exhibits for this preliminary hearing. We thought in this big courtroom, rather than running back and forth with each exhibit, we've given both of the defense counsel a notebook with the same exact exhibits. And what I thought we would do is give this to you, and then at the end, pull out the things that are not admitted, rather than running back and forth, back and forth, back and forth, if that's acceptable to the court.
Any objection from either side?
No, Your Honor.
No, Your Honor.
All right, we'll go ahead and proceed in that fashion. Anything else from the state?
Nothing, Your Honor.
Anything else from the defense?
No, Your Honor.
No, Your Honor.
All right, the state, are you ready to proceed? Do you wish to make an opening statement?
We do, Your Honor.
Go right ahead.
Your Honor, on March 16th of 2014, at about 7:30 in the evening, here at the foot of the Watermelon Mountains, this is right, the U-mound. They call it the U-mound, I think, because there was used to be a U on it before environmentalists took it off to the University of New Mexico. At that U-mound, on the 16th at 7:30, there were 19 men surrounding one man alone. in the foothills of the Watermelon Mountains. And those 19 men, and here they are, came over the course of 3 hours in 3 waves. Excuse me. The first wave was this group at the top, the first 2 that came first. The second wave was...
I'm sorry, Your Honor, can I
Yes, you can move.
to try and get a view?
Second wave of officers were the field officers, what we like to think of as the talking team, to come talk to the man who was on the mountain. The third wave was the TAC team. And it was these 19 men against one individual, that was Mr. Boyd. Those 19 men had armor. And let me pull that up just one second. You can see those pictures of the body armor that they had there. Each of the 19 of them had either a bulletproof or bullet-resistant vest, and each of them were geared up even more. Once you get to the TAC officers, they're geared up even more than the field officers are. Mr. Boyd, of course, had nothing, had no armor. All he had was a couple shirts. I think he had two shirts on, like sometimes homeless people do. And as it got colder, he put on a sweatshirt, which he asked specifically Detective Sandy and the officers who were with him at that point not to get blood on, because it had been a gift from a friend of his. In addition to the armor, those 19 officers had 19 automatic or semi-automatic weapons. Among them, they had 730 rounds of ammunition, which are depicted in this picture. Mr. Boyd, of course, had nothing, had no pistols in his possession. Among those 19 officers, they had 9 automatic or semi-automatic rifles. Among those rifles and among those men, there were 769 rounds of ammunition. Mr. Boyd had no rifle. In addition to that, they had 7 handheld tasers, which are with a range of 15 feet. Among them, Mr. Boyd had no taser. Excuse me, I'm going the wrong direction. They had among them 3 beanbag shotguns, which are known as less lethal options, which shoot a projectile that hurt you when they hit you. Mr. Boyd, of course, had no beanbag shotguns with him. And they had among them 10 cans of mace spray. I think they have a technical term of it, but it's the thing you spray on somebody to make sure to try to disable them. Mr. Boyd did have a can of mace. Homeless people often are victims of crime, but his was empty. He pulled it out at one point, but in fact, when they seized it from him, it had nothing in it, and he put it away at one point. They had among them, the officers, 3+ knives. We say 3+ because those are the only 3 we can see. Most of the officers, I suspect, had them in their pockets. In one of the pockets, particularly the TAC officers that have all these pockets, had knives in their pockets, but the ones we can observe from the photographs that were taken, there were 3 knives among those officers. We expect there were many more than that. And Mr. Boyd had 3 pocket knives. 1 that remained folded and in his pocket, 2 that made their appearance at various points in this encounter with the police officers. They had 2 trained police dogs. Mr. Boyd, of course, had no dogs with him. They had over 1,000 hours of training between them in how to arrest a subject, how to control a subject, how to take down a subject. Mr. Boyd had none of that training. And of course, all of these officers had homes or apartments to go home to. Mr. Boyd, the only place he had to live was up here in the mountains of the foothills, and we'll show you pictures, closer pictures of a little tent encampment he'd made there. He didn't really even have a tent. He had all of his belongings, all of his worldly goods there, covered up with a tarp. Everything he owned was there in that particular campsite. Okay. All of these men, at the time of the shooting, surrounded him. He was in the middle, and all of these officers had encircled him. The only possible way he could have run, and we've done this picture because, so you can see the direction of where the mound is. This is a closer up version of this, Judge, is uphill. Is the only place he had to go. That's the only open space he had to go. Otherwise, he was completely surrounded. What was the crime that prompted this massive paramilitary response? It was not a terrorist act. It was illegal camping. It is the kind of thing that most of the time you don't even give a ticket for, Judge. You come out, you say, you can't be camping here. We're going to give you until tomorrow to move all your things. We see you've got all your stuff here, so you can't move it right away. We'll give you to tomorrow to come back. We'll come back and make sure you're gone tomorrow. If sometimes you can write a citation, but you never arrest somebody for that. It was illegal camping. And the question for the court is, when the odds were 19 heavily armed men versus one person in a sweatshirt, was it reasonable to fear the lone man on the mountain and shoot him twice in the side and once in the back as he tried to obey the officer's orders to get on the ground? Some people have even asked this question, which is, really, who was acting in self-defense? Was it the officers or was it Mr. Boyd who was reacting to the unreasonable use of force? We have given you a brief on these rules that guide your decision, but I want to run over them and then talk about the facts that fit each of these rules. It is not self-defense if the officers start the fight. That rule applies whether you're a citizen or an officer. If I pull a gun on you, Judge, and you pull a knife on me, I don't get to shoot you in self-defense because I've started the fight. Same is true as if I'm the aggressor and I start beating up on you and you defend yourself against me. I don't get to claim self-defense if I start the fight. Secondly, I don't get to claim self-defense if I create the danger, and we'll show you what we mean by that in a second. If I create the situation where I say, now I made this happen and now I feel like I'm at risk, so I had to shoot you because I created this situation that was dangerous. Third, you're not allowed to claim self-defense if the citizen has surrendered to you and is not an immediate threat. And we'll talk to you in a minute about how that happened in this particular case. Let's talk about starting the fight. Here's the timeline. Some open space officers were dispatched at about 4:30 in the afternoon up to this area, called the neighbor. And there are two times actually, both at the beginning and the end of this, that sort of bookend this encounter that are really important for this case. 11 seconds at the beginning and 11 seconds at the end. Both of which are the times when they provoked and started the fight with Mr. Boyd. These open space officers walked up to Mr. Boyd in his campsite, and he was laying in his tent on a sunny day. He was doing nothing. He was laying sort of in this little area where there was the tarp over it with his feet up. And they walked up to him and they said, "Hey, how you doing?" He was completely pleasant and polite to them. They could see one of his hands here. They just could not see his other hand. And so they said, "Show me your hands." Excuse me, they didn't say, "Show me your hands." They said, "Come out of the tent. Can you come out of the tent?" And he didn't move fast enough for them. And within 11 seconds of encountering him the very first time, when he was being polite to the officers, he did not show any aggression to the officers. Nothing had happened. Within 11 seconds, these officers pulled their guns. And the taser camera footage that we have of this is just the shadow of them, because it was on the taser cam, so you aren't seeing what's happening with Mr. Boyd, but you can see the officers pull their guns, both of the open space officers, within 11 seconds of encountering him. The second time that they attacked Mr. Boyd and started the fight with Mr. Boyd is when he surrendered to them. And that is in the last 11 seconds, right before the shots are fired. He said, "I'm coming down, I'm surrendering," and they threw a flashbang grenade and attacked him as he surrendered. Those are the two times. Here are the open space officers, Officer Hernandez, Officer McDaniel. And this is what I was just talking about. Although he was polite, within 11 seconds they pulled their guns on him. Interestingly, his mental illness became immediately apparent to him. He began talking about, "I've been calling you guys." Talked about the Department of Defense. There's a matter of national security, all the things that they're trained to recognize as somebody suffering from mental illness. Mr. Boyd, in fact, did suffer from paranoid schizophrenia. And what the training says that you should do as soon as you know somebody is suffering from mental illness is that you should not touch them. You should not touch them. You should back away, because not only is it a safety issue, but because people who are suffering from mental illness, particularly paranoid schizophrenia, don't want to be touched. And touching them may set up an episode. And Mr. Boyd, who had gone out to live in the wilderness out there on the edge of the city, because he doesn't have a car, he has to be close enough so he can come into town to get the food that he eats, and he had some of it there, a little box of Church's fried chicken, but far enough away where he isn't encountering people and causing problems. I mean, for a person with Mr. Boyd's problem, even living in a homeless shelter is a problem for him, because there are people around him, and with his kind of illness, there's conflict even there. So he had gone out to live on his own. What they said is they saw, one of the officers said, I see a pocket knife in his pocket, which is, again, it's not even a weapon according to New Mexico law. There's a case, State versus Nicar, that says a pocket knife is a tool. Not unusual that somebody camping would have a pocket knife in their pocket. And the officer then, with both of their guns still drawn, said, well, we're going to have to pat you down, and and before he touches him, Mr. Boyd says to him, please don't touch me. Please don't touch me. And the officer insists on touching him. So I insist, and he grabs him to spin him around. And it's at that point that Mr. Boyd, for the first time, with both these officers pointing their guns at him, with them touching him after he's asked them not to do so, that's the time he very first pulls the pocket knives that he has and opens them up. And he holds them in a way that you will see throughout this encounter. He pulls them out and holds them down with the blades pointed down about waist high. Sometimes they're a little bit higher than that, but as a defensive gesture and not as an offensive gesture. That's how he holds them. And the officers recognize that, and even though they were within arm's length of him at the time this happens, he does not come after them. And they don't shoot him. They recognize he's trying to back them off. It is a defensive display. They back away from him and follow their training about backing away from him and creating distance. Distance, that's what keeps you safe. And Mr. Boyd does not follow them, does not pursue them, does not take any aggressive moves towards them. He stays up there with his knives and begins to complain about something that he does through the next 3 hours. There are two things that we take from this initial encounter. Here's Mr. Boyd's complaint, and you hear this over and over again as the other officers arrive, and the call they arrive to is that this guy's attacked these officers with a knife, which is not what happened at all. What he keeps saying to everybody who will listen, it's sort of the cry of every person who feels like they've been abused or had excessive force by a police officer. You attacked me for no reason. I was doing nothing. At one point he says, what if it was the governor's kid up here camping? You shouldn't be doing this to anybody. You shouldn't be pulling guns on people. And he keeps saying, you're the ones that attacked me. You're the ones that pulled the gun on me. And what he keeps saying as a result of this encounter, he keeps saying to them over and over again when they're trying to get him to come down, I don't trust you not to hurt me. Now, whether that was because he knew it and can read and knows the history of APD and shooting of homeless people, or whether it was just the situation that made him uncomfortable, this initial thing, he kept saying to them, I don't trust you. I don't believe you. When you tell me I can come down, I don't believe you. I think you're going to hurt me if I come down. And he says that over and over and over again. It turns out he was right. Secondly, important, and you'll hear this, I think, a lot in this case too, these officers were following their training from something known as the Tuller drill. This was a drill created by a lieutenant from the Salt Lake City Police Department named Tuller. It wasn't scientifically vetted. It was, they're just at the range and somebody says, Lieutenant, how long would it take somebody with a knife to get to me? And he said, well, let's just do it. You just run at me, and we'll see how long it takes an officer to pull his weapon out once somebody decides to attack him. And after doing that a number of times, Lieutenant Tuller wrote an article saying, it is possible for someone with a knife to get to an officer who has his gun in his holster within 21 feet. And this becomes a 21-foot safety zone rule. That if somebody has a knife, you need to back up 21 feet if your gun is in your holster, because if they decide to run at you, that's how long it's going to take you to pull your gun out. However, if your gun is already drawn, you can be closer than 21 feet and still be in the safe zone. What is never acceptable and what happened here and why they're the ones that created the danger is this. You are not justified to shoot somebody simply because they're within 21 feet of you. Now, in this situation here, if I'm an officer and I want to shoot you, I can't start walking toward you with my gun and say, oh, now the guy had a knife and I was within 21 feet of him, so I had to shoot. You created that situation. Same is true of this second situation. If you have people with guns drawn, Judge, same thing. You can't come within even that distance and say, now you were a threat to me because I approached you, and so I had to shoot you because you created the situation. You're not allowed to do that. That's impermissible. These officers, the two open space officers, always stayed within a safe distance of Mr. Boyd, never had to shoot him, and began to call for backup is what happened with that. The first group of people that arrived, the talking officers, was this group of field officers. And as is protocol, when there is somebody who has mental illness, they sent two what are called CIT officers, crisis intervention trained officers, officers who are specially trained to deal with mentally ill people. And those officers arrive, and for the next, about hour and a half, they are talking to Mr. Boyd. And during this time, he keeps saying things to them like, you attacked me, this is unfair, you attacked me, sort of this cry from the mountain about this is so unfair. They continue to talk to him. They call out some state police officers thinking they'll be able to negotiate with him. But everything is going fine during that time period. He makes it apparent that he's mentally ill. He raves about conspiracies and people who are out to get him. He talks about having millions in the bank. He does all kinds of things like that. And 4 or 5 times during this, when they try to get him to give up his knives, when he thinks they are going to approach him or hurt him, he pulls out his pocket knives again. And he does it 4 or 5 times. He does it the same way every single time. He pulls them out of his pockets. He puts them back in his pockets. He pulls them out of his pockets. In fact, for 99% of the time that Mr. Boyd was dealing with these officers over these 3 hours, the knives were in his pockets and not out. But when he would feel threatened, he would pull them out in a defensive gesture to back them off. It reminds me of a feral cat sort of in a corner hissing and spitting and saying, at them, who really isn't a danger to you, but is more afraid of you than you are of it. And is trying to back you off and stay away from me, stay away from me, stay away from me. That's kind of what the next hour and a half is like. Nobody shoots him. Nobody shoots him during that entire time. By the way, I forgot this part. At one point, he does throw a sandwich at them, and he also throws a biscuit at them from his church's fried chicken, and one of the dogs eats it, and he says, that's fine, the dog can have it. I mean, that's the kind of encounter that's going on. But the only weapon that is obvious he has, if he's throwing biscuits at them, is these 2 knives that he puts in his hand. No one shoots at Mr. Boyd during that time period, Judge, because they are outside the safe zone. They stay in the safe zone, they continue to talk to him, nothing bad is happening. And that continues for about an hour and a half. And here is sort of a picture of all of those officers. These are the field officers, and you see how they're dressed. They're just dressed in regular police uniforms. The only person who has a gun out is Brock Nipreth, who will come testify for you. He's providing lethal cover. All the rest of them have their guns holstered because they recognize, even though Mr. Boyd is ranting and raving and occasionally pulls his knives out, as long as they are outside the safe zone, he's not a risk to them, and they can handle the situation. This situation is completely under control. They maintained a distance of 20 feet. They had available a non-lethal beanbag shotgun. At one point, they say to Mr. Boyd, when he's pacing back and forth, they say, this is a beanbag shotgun. Here is the line. If you cross that line, we're going to shoot you with this beanbag shotgun. And for that 1.5 hours, Mr. Boyd never crosses the line, never runs at the officers, never threatens the officers. And he stays behind the line, and they stay behind their line. And then there's the lethal cover provided by the trained CIT officers. And then something changes. They call for one more piece of less lethal force. They put out a call on the radio for a taser shotgun. They did not call for the tactical team. They did not call for SWAT. They asked for a less than lethal option. And then everything changed. Because that's when the shooting team arrived. And why did the shooting team arrive? It's because of Keith Sandy. Keith Sandy came to APD from the New Mexico State Police. He lost his job at the New Mexico State Police, and when APD lowered its standards for police officers in 2007, he was hired by APD. His goal always was not to be a field officer, but to be a tactical officer on the rope team. You may have had some cases with the rope team, Judge. It's the Repeat Offender Project. It is a group of tactical officers, not SWAT, sort of a step below SWAT, who respond to people with long criminal records. That's what he wanted to do. He had been on the rope team for about a year and a half. He said that he idolized all the people on the rope team. That's all he ever really wanted to be. And unfortunately for Mr. Sandy, during that year and a half, he committed a very big mistake. He was in a blocking maneuver and he messed it up. And the person got away, and he became sort of the butt.
I'm just going to object. This is completely not relevant, and it's simply being used to prejudice you, Your Honor. And even being used in opening, I've not been furnished with any documents of the sort of these. So I just object.
Judge, this is all in Mr. Sandy's statement, the second statement that he gives to APD. This is all in Mr. Sandy's statement. And I will...
I'll allow you to proceed. I understand that opening statements is not evidence. Go ahead.
All right, Judge. Mr. Sandy, in his statement to Jeff Stone, the second statement he comes in and gives to APD, says, I messed up in this blocking maneuver, and they then began to tease me in the group. And the teasing got so bad in the rope thing that they had to develop a safe word, something called China, that when it got too bad and it started getting under his skin and bothering him, he could say China and they would stop riding him. That's important to know why this next thing happens, where he was in rope. Trying to sort of fight his way back to get the respect of the rope unit. Because he gets the call, Judge, over the radio, not for the rope team, not for the SWAT team, but for a taser shotgun. And he responds and says that he has one. And he calls back to dispatch and he says, I've got a taser shotgun, I'll come. And dispatch calls back to him and says, oh, I'm sorry, I mistakenly put this out on the rope air. What they really want is someone from the gang unit to bring their taser shotgun. And he makes the intentional decision at that point to say, no, call off the gang unit, I'll respond. And he does. Don't send gangs, I'm coming. He then, and here it is, I got a second call from control stating that Sergeant Carpenter requested gangs and she called rope on accident, and I told her just that I would stay en route and disregard on the gang unit. Okay? His second intentional decision. Even though no one has requested a TAC team and all they've requested is this less than lethal option, he gets on the phone and calls his rope sergeant, Sergeant Ingram, and asks him to call a canine unit, and then he talks to a SWAT officer, McFarland, and he talks to Canine Officer Weimerskirch, who he's worked with before on the rope team. And without anybody asking for any of this, he begins to assemble a tactical team himself. This is not a team like a SWAT team that works together. This is the team that he assembles. All these 1, 2, 3, 4, 5 guys that arrive are people he calls and says, let's go out to this scene. And nobody has authorized them to do that. And part of the problem with this is they get out there, there's nobody in charge. There's nobody, this isn't a team that works together like the SWAT team where there's somebody who makes a plan and then deploys everybody out to the scene. This team just sort of shows up. That's the team. And SWAT comes a little bit later. Instead of grabbing just his taser shotgun, he also grabs his rifle. He decides to grab his rifle. And then, as he gets to the scene outside, and we'll play this for you, he calls, he runs into one of his old state police buddies, a guy named Chris Weir out there, and they have a little banter about what are you doing here. And he says, They called state police for this effing lunatic, although he doesn't use effing. I'm going to shoot him with a taser shotgun here in a minute. So he reveals here his different approach, not a CIT approach who's been trained to deal with mentally ill people, but his approach to this particular situation right out there in the hallway. And here is the transcript. I'm going to shoot him with a taser shotgun here in a second. But this before he has seen anything, before he's been out to the scene, before he's assessed the situation. He knows the man is mentally ill, and that's how he deals with him, and that's what he calls him out there on the street. Let me see.
What do they got to say? What do they got to say? I don't know. Did I ask for a quickly? This fucking lunatic? You got a pickle? I just had a big shotgun? Yeah. Oh.
We submit, Judge, that was an inappropriate thing to even be thinking about before he'd even assessed the scene. And it gives you something about his mindset and his intent. What happens next? They arrive at the scene, and up there they see what you saw in that first picture, the field officers all with their guns not out, only one officer with a rifle. And he says, I looked at that and I thought that was terrible. And so they call off the field officers. They said, we thought that was unsafe for them to be where they were. And they make a decision, again, without checking with any superior, without checking anybody in authority. They tell all the field officers to come down, and they put them all on the perimeter. And Sandy and his TAC team make that decision. You guys come down and we'll take over for you. Interestingly, they don't even take the time to find out who the officers were that were there. They don't take the time to find out that there were already 2 CIT officers. Later on in this encounter, they start calling down to see if somebody can send a CIT officer, because they don't even realize they already had 2 CIT officers there. And what the CIT officer will say is it's best that you keep the same person talking to the person at all times, that you don't switch people out. And now they start all over, and because there's no CIT officers on this team that Officer Sandy has assembled, the person who does the talking with Mr. Boyd is the canine officer, because he sort of focuses on the canine, and that's who ends up doing the talking without any CIT training. That's who now starts this process with Mr. Boyd. Interestingly, after they've moved the field investigators away because they're too close and they're unsafe, this team eventually moves to the same exact position the field officers were in, the position that you saw about 20 feet away. And they moved them back, saying that they thought they were not safe, and they move up, but all of their guns are out when they move up. And here it is. We moved to a larger rock where the uniforms were originally and stayed there, even though the whole reason he says he sent the field team away is because they were in danger. Then, the whole reason that Officer Sandy was called, to bring less lethal option. When Sergeant Ingram arrives, he gives Sergeant Ingram his less lethal taser shotgun. And he volunteers to be the lethal cover with his rifle. That's a decision he made. He didn't do what he was asked to do, which is just bring the taser shotgun. At some point, another officer arrives, SWAT officer Anthony Settler arrives with a beanbag shotgun. Again, less lethal, not a lethal option. They send him away to the perimeter. Later on, they'll start calling for people with a beanbag shotgun. They actually send that person away within minutes of the shooting. And then, about 7:15, this TAC team comes up with a plan. No matter what Mr. Boyd does, whether he surrenders, whether he puts down the knives, no matter what he does, they are going to attack him. And the plan is to hit him with a flashbang grenade. I don't know if you've experienced that, Judge. It's a diversionary device, big explosions designed to disorient you, distract your attention. Hit him with the taser shotgun and stick the canine on him. That is their plan, regardless of what Mr. Boyd does. And Mr. Boyd, after 3 hours up there, decides to surrender. He says to them, I'm trusting you guys to keep your word. I'm going to try to walk with you, keep your word. Don't try to harm me. I'm not trying to harm you, all right? And he picks up his belongings, and for anybody trained in CIT, you recognize that if his hands are full with his belongings, He's not a threat to you as he comes down. If you need to take him into custody, you can pounce on him and take him into custody because his hands are full. And as soon as Mr. Boyd says, I'm trusting you, and starts, I think he takes 2 steps. You'll see it on the video, Judge. He takes like 2 steps down towards them with his bags on his shoulder. They implement Mr. Sandy's plan. Officer Sandy throws the flashbang device right at his feet, and then he raises his rifle at Mr. Boyd. And there's a picture of that, Judge, where they threw the flashbang and it goes off. They, at that moment, where Mr. Boyd had surrendered, started the fight, and they cannot claim self-defense as a result of that. But they did something else. They created the danger, because it was not Mr. Boyd who came at them, Judge. It is not Mr. Boyd who ever ran at them. In fact, when they hit him with the flashbang, he never took a single step forward towards them after they hit him with the flashbang. He stayed in the same position. And you'll see it on the video. He stays in the same position, and all of these officers move up on him. That's what happens. They created the danger by moving close to him rather than him moving close to them. And here it is. Here he's grabbing his bags and coming down. You see how far away they are? I'm going to try to walk with you, he says. He turns around to come down, takes 2 steps. That arrow is, you can just barely see it on the tape, Judge. It's the flashbang being thrown in the air after he takes 2 steps towards him with his belongings. There's the flashbang going off. There's the smoke from the flashbang. Then what they do is they actually, I think I missed that one. They shoot him with a taser. That was the second part of the plan. And then they stick the dog on him. And then, as the dog is running towards him, all of the officers move in and approach him to go out of the safe zone into a zone that they're now going to claim, oh, we were in danger now. They move up on him. That's what happens. See the movement? That's what they do. And they themselves created the danger for which they can't use self-defense. Finally, if a citizen is surrendering and is not an immediate threat to you, you can't shoot them. I mean, you just can't do it. That's the rule. If they're not an immediate threat, you can't shoot a citizen. What happened in that regard? As soon as the dog runs up and then runs back, by the way, you'll hear why that happened. The dog actually never bites Mr. Boyd. When the dog runs up, Mr. Boyd puts his hand out to stop the dog from biting him. The dog actually gets close to his hand, then turns around and runs back. And the reason why is this was a completely stupid plan. And in fact, Scott Weimer's said, I didn't think that was the plan, because you never use a taser with a dog. And the reason is, Judge, the dog are trained with shock collars. So when you don't want them to bite something, they have a shock collar and you shock them. So what happened when the taser hit Mr. Boyd and the dog ran up to him, the taser was cycling, and the dog thought it was sending him a signal not to bite the person. And so the dog turned around and ran back. But they moved up behind him before the dog ever came back. They're going to say, oh, we went up to protect the dog as he was coming back. That's not really what happened. What happened was they ran up with the dog, and then the dog turned around and came back. But Mr. Boyd never got bit by the dog. He put his hand out, and then after the dog came, in response to the dog attacking him, he did what he'd been doing 4 or 5 times over the last 3 hours with no consequence at all. He pulled his knives out again in the same exact way that he had pulled them out before. And the officers responded by yelling to him, get on the ground, get on the ground. And he turned to get on the ground. You will see that he is standing on a slope with rocks. He could not lay down forward. He could not get on the ground forward. He had to turn uphill and lay down, face down on the ground. That's the only way he could follow their instructions, was to turn and lay on the ground. And that's exactly what he does. Here is, they yell, get on the ground, and he begins to turn to his left to lay on the ground. And it is at that point, when he is turning to follow their command, that Officer Sandy fires 3 shots. And here's how the shots go, Judge. So if Officer Sandy is over here, as Mr. Boyd turns, first shot they're both into his sides. The first shot hits him here in this arm. You can see in the video, and we'll show you with our person reconstructing it, actually catches his clothing. He was trying to shoot him in center mass, catches his clothing here, goes into his arm and out the other side of his left arm. As he's turning, the next shot hits him here, right in the humerus of his right arm. It completely shatters his right arm. They had to amputate his arm to try to save his life because with these soft point bullets, that's what happens. It goes out his left arm and hits a rock over there. And then this happens. By the way, Officer Sandy shoots 3 rounds before Officer Perez ever shoots. All 3 rounds, he hits him twice. Officer Perez doesn't shoot until Mr. Boyd is almost completely laying down, and he shoots him right about here, Judge, in the back, here. And because he's laying down, about to lay down, the bullet goes all the way up through his body, through almost all of his organs in the middle of his body, and ends up right here in his left shoulder, and that's the one bullet that we can recover and identify. Here he is in slow motion, Judge. That's Officer. So the officer up to the left, the one closest to him, that's Officer Sandy. He shoots 3 times, and as Mr. Boyd is, you can actually see the trace of the bullets, and we'll show you some pictures of the trace of the bullets as Mr. Boyd is laying down, doing what he was commanded. That Officer Perez, after Officer Sandy shoots his 3 shots, he begins his shot. His first shot hits him in the back. The other 2, because Mr. Boyd is laying down, go over Mr. Boyd and miss him completely. Here's what I'm going to show you. Officer Sandy's perceptions are key to his intent, Judge, and whether this was self-defense. What Officer Sandy says in his statement that was taken 2 days after the shooting was that he was holding the knives in a defensive posture. Not offensive. Not offensive. Not trying to stab them, not this way, holding them the same way he'd done throughout the encounter and for the whole 3-hour encounter, to back them up because he was afraid. And that's what Officer Sandy says that he saw, that he was holding them in a defensive posture. Officer Sandy says, I made the decision that because of the proximity and the knives that I was going to engage him with my rifle, which is police speak before I decided to shoot him. But remember, it wasn't Mr. Boyd who came to them, it was Sandy and Weimerskirch who moved within 3 feet of Mr. Boyd. They're the ones that moved up on him, not vice versa. And here's his quote. I had made the decision that because of the proximity and the knives that I was going to engage with my rifle, that was an intentional decision. This is also important. His acknowledgement that before he shot, he saw him turning to his left. I come up, I held center mass, and I went to press my first round, and as I did, I observed the male through my scope turn from squared off to me, facing me. He began to turn towards the left, and he appreciated that before he fired the first shot. He understood that the man was turning to his left, and he shot anyway. As he was turning to the left, I fired my first shot center mass. I followed it immediately with a second shot as he continued to turn. So he knew he was turning away from him and was no longer facing him, no longer a threat at all, but decided to shoot him anyway. And then he sees him in his scope. He says he's still standing, and so I decided to fire a 3rd round. And he's still standing. I put my finger on the trigger, and I fired a 3rd time. As I did that, that's when I saw his body fall forward. All of that happens before Officer Perez fires a single shot. 2, 3, there's the Sandy's 3rd shot that misses. And now I want to talk to you about this fella here. Because the defense has said, because Officer Perez shot Mr. Boyd in the back, they have hired a guy who became famous this Sunday when he was on the front page of the New York Times, a fellow named Bill Lewinsky, who has a PhD from an outfit, an experimental college in Cincinnati called the Union for Experimental Colleges, who designed his own curriculum when he was there and made up a specialty program that is not recognized anywhere else in the world called police psychology. He is the go-to person around the country. Anytime a police officer shoots somebody who is unarmed, shoots somebody in the back, or when their testimony is different from the video. And this man is known across the country for coming in, no matter how reprehensible the conduct of the police officers, and saying it was okay. And to try to give an opinion about what was in the police officer's mind and what made it okay. And his testimony has been called by the American Journal of Psychology pseudoscience. The Justice Department has found that it is lacking in scientific foundation and reliability. I'm telling you all of that because before he gives any opinions, after they present his credentials, we are going to challenge him on Daubert and Albarico grounds. And I just wanted to alert the court to that fact. We haven't filed a motion, but we'll see if they can get his qualifications to be what we would accept here in New Mexico. He, even in his New York Times article, bragged about how he was coming to New Mexico to tell us all about what really is reasonable. He's the fellow that says, and trains police officers, shoot first, and I'll come in and answer the questions later. That's what he teaches them. He has made a fortune over the years, and I will tell you, Judge, that both in training, he does training, that's where he makes most of his money, and also expert testimony. The concern is this. He has now started training officers across the country that you should shoot first. And here are the things that you say to justify the shooting. And one of the theories that he uses is something called inattentional blindness. It is a theory that even the person who came up with that theory says he's using it in the wrong way and it's not what applies here. The problem with him doing that and putting that out on the web, articles about how if you shoot somebody in the back you can defend it, is that police officers' statements are taken differently than the statements of anybody else in a homicide. Rather than rounding up the people who are accused and taking their statement right away at the homicide, for police officers, they do it differently here in Albuquerque. Police officer gets to leave and come back 2 days later. He's allowed to look at the videotape. He's allowed to confer with counsel. That's a constitutional right. I'm not criticizing that, but if it were a citizen, they would try to interview the person before they lawyered up. And after he's conferred with everybody he wants to, gotten online to see how you defend a shooting in the back, he then can come in and give his statement. And the one thing, if Mr. Lewinsky is allowed to testify for this court, that Mr. Lewinsky will say, is I can't tell you whether a police officer is telling me the truth about what he perceived and what he saw, or whether he is saying what he needs to justify shooting somebody in the back. What is apparent is that that's exactly what Officer Perez did. And I want to talk about Officer Perez for a second, too. He's a different kind of officer than Officer Sandy. He is served in the military, served overseas, fought for his country, came back in the mid-2000s, I think 2006, and joined the Albuquerque Police Department. Has been on the SWAT team, and he was not involved in the planning of this assault. He was called out by the SWAT team as the SWAT team began to arrive and was assembling. The way the SWAT team works is they have a sergeant who's in charge who was down there. But interestingly, what happened with Officer Perez, they did the same thing with Officer Sandy. The team that was up there called for a less lethal option again, a beanbag round. And instead of sending an officer up with a beanbag shotgun, they sent up Officer Perez while they sent somebody else out for a beanbag shotgun with his lethal weapon. And if Officer Perez made a mistake, it is this mistake, Judge. He did not find out from anybody what had been going on for 3 hours. He did not find out what this man had been doing for 3 hours. I'm not even sure he knew there were 19 people up there. I don't know if he even knew what the lay of the land was. He could see some of the people who were out there, see some of the officers that were surrounding him, and he ran into a situation without preparing himself and having the information that he should have had before he made the decision to shoot somebody in the back. And that's exactly what he did. He, by the way, has been trained in the military, and there's something in the military known as sympathetic shooting, that you're trained that if other people around you begin to shoot, that you need to shoot too to protect the whole group of you. It's not that you even perceive a threat, but you hear somebody else shoot and you shoot too. And I think that's what happened here. That when Officer Sandy shot, Officer Perez shot. His first shot, that's the shot, Judge, that was the most immediately fatal into Mr. Boyd's back. And you can see the tracer of the gun. Mr. Boyd, as you can see, his back is completely to him and is laying down. There is a second shot that goes over Mr. Boyd, and there is a shot that goes over Mr. Boyd, as is apparent from these photographs, as Mr. Boyd is laying on the ground. It is not self-defense, Judge, if the officers start the fight, which is what happened here twice, at the beginning and the end. It is not self-defense if they create a danger. It is what they did when they moved in on this man out of a safety zone and put themselves in danger. And it's not self-defense if the citizen is surrendering and not an immediate threat. At the end of this case, we will ask the court to bind these officers over on second-degree murder, voluntary manslaughter, and involuntary manslaughter, and the two other charges that we've filed because of that. Thanks, Judge.
Thank you. Mr. Frazier. Thank you. Sure, go ahead. May it please the court, counsel. Your Honor, what you just heard was an opening for a civil lawsuit against the city of Albuquerque. 19 people are in charge of the crime. Two police officers are being asked, this government, the prosecution is asking you to hold over these two police officers in a criminal standard. I am surprised, based on their argument, that for perhaps the evidence would indicate to the prosecution that the open space officer should have been charged for assaulting Mr. Boyd with a deadly weapon. I'm surprised that they didn't go as far in their opening, or at least are arguing, that Mr. Boyd would have been justified if he had stabbed the dog handler, Officer Weimerskirtz. This is a criminal case against two Albuquerque police officers who independently perceived the same deadly threat. And these officers, following their training, made the decision to use lethal force to protect an officer from a deadly threat. That is what this case is about. It's not about arguments of negligence on how the police department handled everything on the mountain. It's not about 700 rounds of ammunition. It's not about any of that. The facts that you're going to hear are about two officers following their training, seeing that a fellow officer is in jeopardy of being gravely hurt or killed by a crazy man with two knives. And he was mentally unstable in every way. You'll hear that, in fact, that he says he was the Department of Defense. But more importantly, you will hear that time and time again, he told every officer, from the first officers he contacted until the end, I'm going to kill you. He told officers time and time he was going to kill them. That's the facts. He told officers time and time, I'm going to kill you, and he pulled out knives. Homicide is necessarily committed when a police officer has probable cause to believe he or another is threatened with serious harm or deadly force while performing those lawful duties. And at trial, if they were to be held over, the burden is on the state to prove beyond a reasonable doubt that the killing was not justifiable. That is the law. That's what these facts have to be judged upon. Now, on March 16th, 2014, Keith Sandy necessarily shot James Boyd. When Mr. Boyd, a mentally unstable man who was holding a knife in each hand, was approximately 9 feet away from Officer Weimerskirtz, when Boyd took an aggressive step, and you will see that time and time again. I'm sure by the end of this week you will have seen this video more than you ever cared to. But it was approximately 9 feet away when Officer Weinerskirts, when Mr. Boyd took an aggressive step towards him. Officer Sandy, following his training and following his duty to protect a fellow officer. His job that day was lethal cover, and that's the only job he had that day. Yes, he went up there with a taser shotgun, but at the time he was right there when the decision was made on whether or not to shoot Mr. Boyd, his only job was protecting this officer that was right next to him. That's all his concern was. That's his only concern. And when Mr. Boyd, who threatened to kill officers time and time again, when Mr. Boyd, who they learned through information over the radio and through the computer system, had been violent with police officers time and time again, Mr. Sandy followed his training. And he made a split-second decision to use deadly force on Mr. Boyd. Now what's interesting, and which perhaps is one of the most important facts for this court to consider, is that at the very same time, within a second, and that's what we are talking about, rapidly evolving circumstances that police officers are required to make split-second judgments and decisions. But within that very second or two, Officer Perez, some distance away from Officer Sandy, different angle of Officer Sandy, who had never communicated with each other on that day. Important fact. The evidence will show that they never talked on that day. But he saw the same threat. He saw a man pull out 2 knives and take a step towards Officer Weinerskirts. And he made that split-second decision, following his training, following his duty to protect a fellow police officer. He saw that deadly threat, and he made that split-second decision to use deadly force on Mr. Boyd as well. Now, the government calls that murder. The evidence will be clear that what this is justifiable homicide by a police officer doing his job. As an initial side note, I think it's important to point out that I think the government contends that Mr. Perez's bullet caused the death of Mr. Boyd. Yet the government wants you to hold over Mr. Sandy for murder as well. I believe it's under the novel theory of aiding and abetting. While there is no law to support this theory based on these facts, there is absolutely no facts to support this theory that they are going under. I do not believe, and I don't believe, that there is going to be much of dispute of what actually took place after you hear this evidence on March 16, 2014. At 4:30 p.m., open space officers Hernandez and McDaniel were dispatched to the open space area behind the residence of 812 Piedra Vista Northeast, commonly known as the Albuquerque Foothills. James Boyd, upon contact with these officers, did commit the felony of aggravated assault with a deadly weapon by brandishing a knife and threatening the officers. That's what those police officers relayed to the other officers that subsequently came. That's what he did. They draw their guns, and you'll hear from Officer McDaniel, who'll tell you he was a split second away from shooting him himself. This wasn't about illegal camping. Let's not be strayed down the wrong path here. This was about a man who pulled out 2 knives on 2 uniformed police officers in a very threatening way, and you'll hear that testimony. This is not about illegal camping. And despite how much the prosecution wants you to believe that Mr. Boyd was just out there camping, and he wasn't at homeless shelters, by the way, because he's been kicked out of every homeless shelter because of his violent tendencies. But, you know, he's just up there camping, and they should have just said, move on, sir, move on. No, when you approach someone and he won't get out of the tent for some time, and you finally get him to come out of the tent, and you say, we want to see your hands because that's kind of important police work, And he whips around when you begin to pat him down for officer safety. And by the way, they had the reason to approach him, obviously, because he isn't supposed to be camping there. And then while he's beginning to be patted down, he turns around with 2 knives on these officers. That's a felony under anybody's definition of it. Based on that felony, Mr. Boyd the officers called for additional officers to help them with Mr. Boyd. Additional officers did arrive. A crisis intervention officer arrived. Negotiations began to try and get Mr. Boyd put safely into custody for assaulting police officers with deadly weapons. At this point, additional resources were requested for assistance, including APD rope detectives Keith Sandy, Richard Ingram, K-9 officers Scott Weimerskirts. Your Honor, the point that Officer Sandy said, you know, I'm already en route. Though you can call off gang unit, I'm bringing the taser shotgun. Okay? That's probably a good thing. Don't we want our police officers to say, I'm already doing it, no reason to call somebody else? There's a police officer liking to do his job, they want to make that some kind of evil intent. That's what the government's going to try and do. He arrived, by the way, Officer Sandy arrives and has a discussion with Sergeant Ware from the New Mexico State Police, and they've known each other for some time. They worked on the tactical units together, and they've known each other for a long time. And somewhat locker room talk, he uses the words, he uses the word effing lunatic. Okay? Politically, completely incorrect. Not appropriate. 2 guys talking in a locker room, sometimes language isn't used right. 2 guys getting ready to go up into a tense situation, sometimes they use foul language. But substantively, factually correct, Mr. Boyd actually said he was the Department of Defense. Mr. Boyd said the money in this world was going to run out in just a few months, and Mr. Boyd, most importantly, continued to tell officers he was going to kill them. And these guys knew of his past. So saying that doesn't sound good. There's some evil intention there. And by the way, less lethal force. And you'll hear from Sergeant Ware. And there's been so much discussion about this already, and I don't know if you heard about it, but this is opening statement about whether or not he was shot in a private, he was going to shoot him in a private part. Sergeant Ware will tell you he never said anything of the sort and never said he was ever going to shoot him with any type of lethal force. That's what Sergeant Ware will tell you. I was talking back and forth. Why are you here? I'm here with a taser shotgun. Less lethal force. So after these officers arrive, SWAT officers are also called to the scene to set up a perimeter around a very violent man. Information, as I said, was relayed to the officers on the scene that Mr. Boyd had a violent past, including aggravated battery on a police officer. Over the course of time, when talking to Mr. Boyd threatened numerous times to kill the officers. Mr. Boyd brandished the knife several times while verbally threatening the officers. Mr. Boyd not only refused countless requests for him to give up the knives, but every time he was asked, he'd get more agitated. Those knives were something that were very important to Mr. Boyd. These negotiations between Mr. Boyd and the officers on the scene lasted for hours. The incident began at 4:30 p.m. in the afternoon. By sunset at 6:14 p.m., Mr. Boyd would still not disarm himself of the knives. It was starting to get dark. And the officers at the scene were concerned about an unlighted area, no ability to lighten up the area, no real ability to lighten that area, no car lights, none of that. Darkness was absolutely approaching, and Mr. Boyd, perhaps somehow with knives in his pocket, would be able to gain the upper hand and somehow slip away. Could possibly hurt officers, could possibly hurt the neighbors, could possibly hurt hikers in the evening hours. All those things were of concern to them. So Officer Weimerskirts, the K-9 officer, Officer Weimerskirts, devised a plan to use less lethal force and disarm him and place him in custody. And apparently using less lethal force, according to the government, there's a problem with it based on their opening. But less lethal force is the exact thing you're supposed to do. That's the way they're trained. To use less lethal force when you have to. At this point, it's dark. They have to get Mr. Boyd under custody. They're not going to let it get completely dark and just let him continue to hang out with two knives. They know he's armed. They know he's threatened to kill people, including officers. So they can't just let him stay there. That's not an option for these police officers. So they develop a less lethal plan. And that's exactly what happens. The flashbang to disorient him. They deploy a taser shotgun. They deploy a canine dog. They let a dog loose. All less lethal means to try and bring him into custody, to gain control over him. And while doing this, continue to give the commands, get on the ground, get on the ground. Instead of making that decision to get on the ground, instead of, after all of that kind of force was being applied to him, make a decision, drop the knives and just say, okay, I'm done, or anything like that, Mr. Boyd, and I'm just doing this as demonstration, pulls out two knives like this, 9 feet away, Your Honor. I will tell you that it's about twice the distance from that, and he's on higher ground. And if we could, and it's up on your screen now, Your Honor. I don't know if you have it up on yours. You don't have it.
It's on his far screen.
Yes. Is it on the other one? It's on the other one behind you, Your Honor. That one. No, it's fine. So as you can see from that screen, Mr. Boyd stands 3.63 feet above, which is 3 feet and 7.5 inches or so, 9 feet away from the officers. He has absolutely the higher ground. Keith Sandy is there's two pictures. There's officers there you can see, and we have it all. You can run this during the hearing, but for these purposes, you will see that Officer Perez is in the background. Officer Sandy is standing up right next to Officer Weimerskirts, who's got the dog. That is the distance between the two. It is 9 feet between those officers and that man. I am 6'2". He is 6'2", Mr. Boyd. My hands reached up like this, coming straight down, are close to 8 feet. He takes one step and takes a leap, and he could put a knife in an officer's neck there. He takes one step. He takes that step. Mr. Boyd was now 9 feet away. He's on higher ground with a knife in each hand, both hands. At this split-second decision, he's standing, sitting right there, knowing his one job is to protect that officer crouched next to him. Makes a split-second decision to deploy lethal force to stop what he perceived as a lethal threat of deadly force on the part of the officer that he is protecting. Dominic Perez, down below, different angle, sees the exact same threat, makes the same split-second decision. Two officers seeing the same threat, following their training, making the same decision. Your Honor, you'll hear from Officer Ingram, now Sergeant Ingram, who was also there. He was right there on the mountain. He's not in that actual illustration, but he's on the mountain with them. You will hear from him about his fear and perceived threat as well. He was manning the taser shotgun. You will hear from Officer Weimerskirts. Weimerskirts will come in and sit in the witness chair and tell you, Your Honor, that these two officers saved his life. That is his perception of the events that took place. That these two officers saved his life. And he is on this earth because of their actions. He'll also tell you how close this violent man, Mr. Boyd, was to them. You'll hear from expert witnesses about officer training and what officers, how they're trained and what they're supposed to be doing when situations exactly like this arise. The Tuller rule was mentioned in the opening that the government gave. It's not a safety zone. The Tuller rule, and you'll hear the training that every one of these officers goes through about people with deadly weapons, with knives. It means the following, that if someone was within 21 feet of you, and they have an edged deadly weapon, they could approach you, stab you before you could ever even pull your gun out to shoot them within 21 feet. Officer Weimerskirtz didn't have his gun drawn. That was Keith Sandy's job, to protect him. But it wasn't 21 feet now. It was 9 feet. And now what we're going to hear is whether or not they should have ever used lethal force. Well, or non-lethal force. That's exactly the way they're trained. When they have to get a subject in custody before it gets dark and they lose any type of ability to do so. The one thing that you will not hear any evidence about, the one thing that no one's going to say, is that pursuant to their training, they shouldn't have shot. I mean, you're not going to hear anybody say they shouldn't have taken a shot. You're not going to hear any expert. You're not going to hear anybody giving an opinion, and I know what the judge has been ruled on the opinion so far. But you're not going to hear from anyone that says, in that type of a situation, anything other than, we are trained to shoot him. That's what the evidence is going to be. No one will testify that this is not the proper response to the deadly threat of a man with a knife 9 feet away and taking an aggressive step towards a police officer. Because that's what they're trained to do. A couple of more things I'd like the court to pay particular attention to when you hear the evidence. Keith Sandy's only job, as I mentioned, was to protect Officer Weimerskirtz. He wasn't supposed to engage Mr. Boyd verbally. He wasn't supposed to do anything else on that day except protect him. I mentioned this also, the second thing I'd like you to consider. Officer Perez and Officer Sandy, they never spoke to each other or communicated with each other. Yet the government says, and they have charged Mr. Sandy with aiding and abetting, which requires, based on our court cases, that Mr. Sandy intended Mr. Perez to do what he did. It's a hell of a stretch, Your Honor. And I think at the end you'll see that the facts don't support any type of such a charge. And the final thing I want you to consider, and I know the court will, throughout all this, and they showed some slow motion, and I'm sure counsel for Mr. Perez will show some slow motion. But today and tomorrow and the rest of this week, we are in the confines of this courtroom where 20/20 vision may be absolutely crystal clear about any particular quarter of a second or half a second. But these two officers are required to make split-second decisions and judgments in circumstances that are extremely tense, circumstances that are uncertain, and with huge responsibility protecting the lives of another officer, for example, and rapidly evolving. And we have a duty here, Your Honor, and the law requires us to allow for the fact those split-second decisions have to be made in very rapidly changing circumstances. I told you at the beginning of this opening that the state's burden, if you were to hold Mr. Sandy over, would be to prove to a jury beyond a reasonable doubt that shooting in Mr. Sandy's case was not justifiable. If they provide you with no such evidence,
You can't hold over, Mr. Sandy. Thank you, Judge.
Thank you. Robles?
May it please the court? Go ahead. Without question, this is a tragic case. Tragic for Mr. Boyd, but it's also tragic for my client, Officer Dominique Perez, as well as the other officers whose lives were forever changed as a result of what happened on March the 16th, 2014. Even though Officer Perez had no other choice but to use deadly force to protect his fellow officer, this isn't how it should have turned out. How simple it could have been if Mr. Boyd had listened to one of the numerous times officers asked, cajoled, and pleaded with him to simply put down the knives and submit to custody. But Mr. Boyd chose a different path, and that's why we're here. Again, if Mr. Boyd had simply cooperated, had simply listened, had simply done what he was asked to do, none of this would have happened. But instead, we have a criminal prosecution against an officer who fulfilled his duty to protect his fellow officer, K-9 Officer Scott Weimerskirch, and for this, he's being prosecuted. This is indeed a tragic case. Now, we will spend the next week analyzing and reviewing and cross-examining eyewitnesses and experts, trying to dissect and figure out if what these officers were asked to do in seconds was reasonable. Now, the law is wise. The law does not allow the Monday morning quarterbacking, which the state has suggested in its opening argument. Instead, what the law requires of this court is that you view the circumstances in the shoes of the officers, that you are in Officer Perez's shoes, and when you view those facts, you understand them as what they are. They often work, and in this is certainly such a case, those circumstances are tense, uncertain, and rapidly evolving. That is how you look at it. And that Monday morning quarterbacking is inappropriate, because everyone has 20/20 hindsight. But these officers, having been asked to make these incredibly difficult decisions, don't have the benefit of reflection, the reflection that this court will have. And again, that's why the law is wise. Don't go there, because that's not reality. Now, with regard to the incident at hand, I'd like to point out some facts that I think will help this court understand that the state's position on what occurred simply doesn't match up with the evidence you will hear. At 4:30 p.m., the Albuquerque Police Department dispatched two officers, Officers John McDaniel and Officers Patrick Hernandez, to a residence, 812 Piedra Vista. Behind that house, there is a city open space, and in the open space, the 911 caller, Alex Thixton, saw an individual who had been camping in the open space and called 911 to report this crime. And let's make no mistake about it, this was the investigation of a crime. Under city ordinance, section 5-8-6L, camping in the open space is prohibited without a permit. And according to the city ordinance, and this is section 5-8-99A, any person who camps in an open space without a permit is committing a misdemeanor. So again, we have an eyewitness call 911, that crime is reported, so these officers are dispatched to the call, Hernandez and McDaniel. They meet with the 911 caller, who then tells the officers exactly what he told the 911 caller. So now we have an eyewitness to a crime who's reporting to the police officers what they had witnessed. So these officers then make the decision to continue their investigation armed with reasonable suspicion. As fundamental as that is, I want the court to understand that these officers didn't go to roust Mr. Boyd. They went to investigate a crime, which under state law they have a duty to do so, especially when it's brought to their attention. And again, at 4:30, it was a bright, sunny day. These officers were in full uniform, badges of office, shoulder patches, no mistaking that they were open space officers. Now these officers, because they thought that it was probably prudent, walked to the trailhead at Copper, and they walked their way to Mr. Boyd's campground. So in the open, they walked approximately a half mile, never trying to conceal their identity, never trying to use concealment to approach tactically. They walked up, and they did not exercise noise suppression because they wanted to know, they wanted to make sure Mr. Boyd knew they were approaching. And when the officers approached Mr. Boyd's camp, they saw that he was awake. They didn't rouse him from a sleep. He was awake and saw them coming. And what appeared to these officers, Mr. Boyd knew someone was coming. And what about this whole idea that these officers, McDaniel and Hernandez, were aggressive? Now you will hear Officer McDaniel's taser camera. And it's not so much what you see, it's what you hear. The first words that you will hear from Officer McDaniel are, "How's it going?" Now, it wasn't said in a command voice. It wasn't said in an aggressive tone. And you will be able to hear that he said it in a friendly tone, in a respectful tone. There was no aggression here. But what these officers saw does concern them. And that is that Mr. Boyd is inside his encampment, and he's not moving, he's not responding to them, and there is a right hand that they cannot see. And again, it's the hands that hurt, it's the hands that kill. And until the hands are visible, you don't know what's in them. So they asked Mr. Boyd to show his hands. Now, they announced themselves as Albuquerque police officers, and there is no mistake that that's what they are, visually and auditorily. These are police officers who are there investigating the crime armed with reasonable suspicion. Now, again, the officers asked Mr. Boyd to exit. Initially, it's friendly, but it's clear Mr. Boyd has chosen not to respond as quickly as the officers deem necessary to ensure their safety. Again, what these officers what Officer McDaniel will testify to is that as open space officers, they deal with a homeless population that lives in the open space. And what they find with unfortunate regularity is that for the most part, the homeless are armed with an edged weapon of some sort. And it's a matter of whether, as the state sort of portrays it, it's a tool or it's a weapon. And again, a tool is something you use for the benefit of the person who's using the tool. But when it's used against you, it's a dangerous weapon. Now, Mr. Boyd eventually stands up. And what the officers see is essentially the clip to a folding knife. So right there, they have specific articulable facts that this person, whom they have reasonable suspicion to investigate, is presently armed. With that, they begin to decide that we need to do a pat-down search to make sure we can essentially account for any weapons he might have, which of course is legal. Now, at this point, nothing Mr. Boyd has said indicates that he's mentally ill. The state would have you believe that these officers should, upon seeing him, should have known that he was mentally ill. But the unfortunate reality is that not every homeless person is mentally ill. Not every homeless person is suffering from some sort of mental illness that makes them dangerous. Mr. Boyd happened to be that person, but these officers did not know that going into this situation. So when Officer McDaniel makes the purposeful decision to essentially have Mr. Boyd turn around so he can be patted down, and this is before Mr. McDaniel or Officer McDaniel ever touches Mr. Boyd, and Officer McDaniel will testify as much, it's when then Mr. Boyd wheels around and draws his knives and confronts Officer McDaniel. And again, we're talking an arm's length, if not more. The officers, of course, draw their weapons, go to the high ready, and Officer McDaniel was within seconds of shooting Mr. Boyd. And something to be said about Mr. Boyd, that once confronted with a gun, he thought differently about charging Officer McDaniel. If Officer McDaniel had been slower, who knows where we would be with the murder prosecution of Mr. Boyd over the death of Officer McDaniel. Officer McDaniel and Officer Hernandez then begin to tactically retreat, create distance, all the while ordering Mr. Boyd to drop his knives, drop his knives, drop his knives. And you will hear that said over and over again. And what's interesting about that is that throughout these 3 hours of negotiations, and every sort of way that these officers try to convince Mr. Boyd to separate themselves from his knives, Mr. Boyd would have none of it. So this whole idea that he was surrendering flies in the face of his pure non-compliance with what was a lawful order. Again, once Officer McDaniel and Officer Hernandez create an appropriate distance so that they can ensure their safety, they then changed their approach into a negotiation. So even before the CIT officers arrived, these officers trying to create a rapport with Mr. Boyd, and you will hear that rapport, trying to find out exactly what is happening here, how can we de-escalate this situation, and how, Mr. Boyd, we can help you help us so that this doesn't turn out to be a tragic event. Now, within approximately 20 minutes, you have a number of Albuquerque Police Department officers who show up. And what's inconvenient for the state is the lengths to which these officers went to try and negotiate with Mr. Boyd. You have CIT Officer Monet, who's been mentioned by the state, and you will hear his negotiations with Mr. Boyd. CIT officer has a certain protocol that he follows to try and create a rapport and try to create essentially a way in which to communicate with Mr. Boyd that ensures that we can de-escalate the situation. It begins simply by asking for Mr. Boyd's simple needs. Do you have enough water? Do you have food? How long have you been in this area? Is there any way we can convince you to put down your knives? We have hotel vouchers. They begin this process of trying to, as some officers would call it, put in the hook, to find some sort of common ground with Mr. Boyd so that they could see from human to human that everything's going to work out okay, and go through the process of trying to ratchet down Mr. Boyd's fury. But what becomes clear is that despite these valiant efforts to try to talk to Mr. Boyd is not going to let this situation end peacefully. And in fact, he tells Officer Monet, who is a very skilled negotiator, as you will hear, to stop trying to disarm him with his words. So we know negotiation isn't working. Again, trained crisis negotiators cannot bring a resolution to this case, and they tried for over an hour and 10 minutes. Now, during this time, the scene supervisor, Sergeant Jason Carpenter, is making decisions about what other resources are necessary. Sergeant Carpenter begins to ask for an officer with a beanbag. He brings in, I guess it's Officer Wetterland, who's armed with a beanbag. He also calls for a canine officer, and that's what brings Officer Weimer-Skirch. He asks for the taser shotgun, and that brings Officer Sandy and Sergeant Ingram. So these officers were brought to the location, and the officer's intent was, with a man who's armed with an edged weapon, to deal with it with less lethal tools. And again, the state will not be able to provide you with any case law, either from the state or from the federal system, that says that when dealing with an armed individual who has threatened law enforcement, that using less lethal tools is unconstitutional. Why? Because that's what you're supposed to do, both as a matter of law and, of course, how they're trained. That this particular response is the appropriate response, and it's just a question of, do we have to resort to it? Because let's try talking to Mr. Boyd first, and if need be, there is the less lethal response. And understand this, so that there is this criticism of Detective Sandy, which in many respects that misses the point. Detective Sandy showed up to this situation knowing that there was an armed man who had threatened to kill officers with knives. The law allows the use of less lethal tools to take someone like that into custody. So although the political incorrectness may strike you of what he said, legally, it's an appropriate statement because that's the level of force the law would ask an officer to use confronting the situation which Detective Sandy faced. Now, there comes a time when a tactical officer named Jeffrey McFarland begins to move away the field officers from the location where Mr. Boyd has essentially encamped himself. and other officers begin to take the inner perimeter, and an outer perimeter is created. But being up in the foothills and understanding the topography and the fact that the sun was going down, there weren't enough officers to ensure that Mr. Boyd would be contained. Because once it was dark, and again, inky black in the foothills, you wouldn't be able to see what Mr. Boyd was doing, whether he tried to escape or not, and whether there was enough officers to ensure that Mr. Boyd simply wouldn't get away. And again, I think it only makes sense that those officers were necessary and that those officers were needed to ensure that a perimeter, as porous as it was, actually existed. Now, Sergeant Fox is the sergeant of the tactical team. He heard about this incident because a radio dispatcher asked him to listen to the call. Sergeant Fox made a determination that maybe this is a call that needs to become a SWAT call. But Sergeant Carpenter, the field officer who was there, had not made it a SWAT call. So Sergeant Fox, hearing what was happening, decided to go en route. And he asked three of his officers to join him. And one of those officers was Officer Dominique Perez. And Sergeant Fox will testify to this. Now, Dominique Perez, when all this was taking place, was celebrating his birthday with his family. Again, he wasn't aware of the events that were occurring. No one was telling him what was occurring. But as soon as he logged on and was en route about 7 o'clock, he began to monitor the air, and he began to read what was on the CAD. And of course, this court will have the opportunity to read the CAD and also to listen on the radio track. And what Officer Perez heard and what Officer Perez read is that we had an individual, Mr. Boyd, who had committed the violent felony crime of aggravated assault with a deadly weapon against law enforcement officers. Not only that, Mr. Boyd had a history of committing aggravated assault, aggravated battery against law enforcement officers, not only APD officers, but corrections officers at the Metropolitan Detention Center. Yes, he knew he was schizophrenic, but in terms of identifying the level of threat which a suspect poses to officers, knowing the crimes that the suspect had committed in the past, had committed on that day, were far more important. Because if negotiations had gone well, maybe you can go through the process of convincing Mr. Boyd to release his weapons. But if Mr. Boyd acted as he had in the past and threatened officers and in fact charged officers, again, consistent with his history as Officer Perez knew it, Officer Perez would have to act. Officer Perez learns this information as he's going to the scene. And let me bring up. So at 4:30, you have the first responding officers show up, Officer McDaniel and Officer Hernandez. The shooting happens at 7:30. So 4:30 to 7:30, we have approximately 3 hours during which different officers tried to negotiate with Mr. Boyd. And something that's been left out of here is that not only did APD officers negotiate with Mr. Boyd insisted that the only people, or the only officers who could talk with him were state police officers. They were brought in. They tried to talk to Mr. Boyd, and Mr. Boyd, of course, changed and said, "Why are they here? I don't want them here," even though it was abundantly clear that he had asked for them to be here because he somehow believed in his state of mind that they were liaisons with the military, of which he claimed he was a part. So these officers went to great lengths to try and find the hook, to try and find common ground with Mr. Boyd. But Mr. Boyd would have none of that. Now, again, 3 hours were spent talking with Mr. Boyd. Officer Perez showed up at about 7:15, 7:20. So he was on the scene approximately 10 minutes before the shooting happened. He arrived on scene, he talked to Sergeant Fox, and he was directed, that is ordered, to go and serve as lethal cover for the officers who were confronting Mr. Boyd. He was directed to go there. This was not his choice. This is what he was ordered to do. And as a tactical team member, he did that because that was his job. And he knew going in that his job was lethal cover. If something happened and any plan went awry, he was there to ensure that Mr. Boyd did not carry out with his threats. Now, there was a plan in place. It was a plan developed by Officer Weimerscourge. And that plan was never communicated to anyone outside of those folks who were up on the mountain with Officer Weimerscourge. No one else knew what that plan was. And again, the state takes issue with the fact that Officer Perez should have stopped, basically done his own investigation before he ever went up. But again, that's just not how they are trained. It's also not what the law requires. A police officer can rely upon the statements made from reliable police sources of information, such as a radio dispatch, such as a CAD, and also rely upon what other officers are saying about the nature of the situation without conducting his own investigation. Because if that was the case, nothing would ever get done. If every officer who showed up had to do what every officer who came before him knew. Instead, officers are given the presumption that they can rely upon the information that's given to them. And that's what Officer Perez did. He walked up to that mountain knowing that 3 hours had gone on and that Mr. Boyd had threatened to kill officers, committed the aggravated assault against with a deadly weapon against the two initial officers, and had committed aggravated batteries against law enforcement officers before that. That's what he knew. Now, with regard to the actual implementation of the plan, and this, of course, requires us to slow down the events in a way that these officers did not have time to slow down time. In fact, it's impossible. The plan required or asked for the deployment of a flash noise diversionary device, a less lethal tool. That device, when it implodes, because it does not explode, it delivers a pressure wave, brilliant light, and smoke. And it's the hope that when it is effective, it will disorient and slow the reactions of the person who endures it. So this was an attempt by the officers to try and cause Mr. Boyd to freeze, even for a few seconds. And what did this allow? For the use of the other less lethal tools. And again, one of the things, of course, is this is what the plan was. This is how this device is supposed to work. But what actually happened? And let me show you a video to have you understand that when this device was actually used, it was thrown and unfortunately landed on a boulder of granite. A boulder of granite that was in front of James Boyd. So all of the effect of the flash noise diversionary device and its intention to be able to disorient Mr. Boyd proved ineffective because the rock absorbed the blast and directed it away from James Boyd. As you see, the blast happened in front of James Boyd, and he was shielded by a piece of a boulder of granite, so it did not have its effect. This was a plan that was implemented with the intention of resolving it with less lethal force. That didn't work as planned. There was also the use of the taser shotgun. Again, through the use of an electrical current, the officer's hope was that this would debilitate him long enough, freeze him up long enough, so that they could take him into custody, and he did not have the ability to draw his knives. Those rounds proved ineffective. Again, 2 rounds were fired. 2 rounds did not penetrate as designed. So this less lethal tool did not work the way the officers intended it to. And then there, of course, is the police service dog. Now, the police service dog is not just your ordinary dog. This is a dog who's specially trained to do many different tasks. One of them is apprehension work. And it's not like a dog who bites you and releases and bites again. These dogs are bite and hold dogs. So when they acquire a bite, they hold. And they hold with tremendous pressure. 800 pounds per square inch is what a typical Belgian Malinois will bite with. And when that happens, the typical reaction you have from a human being is the effort to try and take the dog off the bite. The free hands will be used to hit the dog. The free hands will be used to try and dislodge the dog from the bite and will not be used to draw the knives. But something happened. This dog did not perform as trained. Officer Weimer-Scourge, who had been training police service dogs for 20 years when this happened, saw this as an anomaly. This was an aberration. This is not what that dog should have done. Now, what about closing the distance? What was happening there? So you have the use of less lethal tools, and the state brings up the tool year rule. Now, the tool year rule isn't a rule that says police officers should never try to take into custody a suspect who has committed a violent felony crime because you might get hurt. If that was the case, all violent felony suspects had to do is stay armed, and the police would just have to let them go away, because that risks the possibility that somebody might get hurt. But we all know these officers had probable cause to take Mr. Boyd into custody for the crime of aggravated assault with a deadly weapon against the 2 police officers. They had probable cause to do that. And there has to be a purposeful decision at some point to close the distance and take that person into custody. And that's what Scott Weimer-Scourge did. He saw his dog try to acquire a bite, and he believed that it would do so, and that he would have time to, as the dog bit his right hand, to take Mr. Boyd's left hand, use leverage takedown, and put him to the ground, handcuff him, and all that would have happened to Mr. Boyd is a dog bite to his hand. But the dog did something different. This was an aberration. And all the while, this is why Officer Weimer-Scourge goes up unarmed, because his intent was to take Mr. Boyd into custody with less lethal means. And even once the dog releases the bite, Officer Weimer-Scourge tries once again, at great risk to himself, to protect Mr. Boyd from his own actions, and sends the dog back to bite and hold again. But the dog does not perform once again. So we have Officer Weimer-Scourge, who intended to take a violent felon into custody and having probable cause to do so, makes a purposeful decision to try and take him into custody without using deadly force, and that plan did not work. Now, all of these plans, all of these efforts to take Mr. Boyd into custody were unknown to Officer Perez. Again, he knew, because it was mentioned on the radio, that there was a plan, but the details were never communicated to him. So he's processing this as it's happening, not with the calm reflection that the court will be asked by the state to use. Officer Perez walks into this, and it unfolds. It unfolds rapidly. He doesn't get the chance to sit there and wonder, okay, what is my best option? Because if he did that, Officer Weimer-Scourge would have no options but to take whatever Mr. Boyd was willing to give to him. the state contends that Mr. Boyd was going to the ground and that he was surrendering. But what the state failed to mention to you is what the Office of the Medical Examiner will say about the first, what we believe to be the first wound that Mr. Boyd suffered. The first round that hit Mr. Boyd is when he was square up with Officer Weimer-Scourge and Chief Sandy. The round entered his right shoulder. That's clear. The entrance wound is here, and there is no doubt about that. That round struck Mr. Boyd in the right shoulder, and he begins to turn away. A natural human reaction. He's not going to the ground. He was shot and responded to being shot because Chief Sandy knew that what was going to happen next, based on the step that you could see happening there, that within a second, Officer Weimer-Scourge would be in danger, perilous danger, if he did not take the shot. Officer Sandy essentially turns him with that round, and Mr. Boyd continues to turn away. And then he's struck with yet another round as he's turning. But the thing to consider is that we can look at this video and we can say, well, these officers should have known that he was going to turn away. But how do you know in the middle of this that the first step forward is actually a turn? You don't. It's only with 20/20 hindsight that you begin to think to yourself, maybe that's what's happening. Maybe that's what's happening. But 20/20 hindsight is not the standard that you use. And again, this situation happened incredibly fast. And again, let me play for you a video in, essentially at real-time speed for you to get a sense of how fast this actually happened. And again, the window of opportunity to make a decision begins when Mr. Boyd reaches into his pockets. And if that's our starting point to analyze, standing in the shoes of Officer Perez, the decision he had to make, that's what this decision would look like. This cannot be the item of reflection, the item of analysis, because that's not what this situation allowed Officer Perez to do. This is a justifiable shooting. This is a shooting which is lawful and legal. And for this reason, Your Honor, Officer Perez asks that you dismiss the information that's been filed against him and end this tragic case that has essentially forced him to defend himself for saving the life of Officer Weimer-Scourge.
Thank you, Mr. Robles. Why don't we go ahead and take about a 15-minute recess. We'll reconvene in 15 minutes. Court's in recess.
All rise.